Okay, good morning everyone. I would like to welcome both parties to this mediation session. My name is AMIRUL HAKIM and I am the certified mediator appointed to facilitate your discussion today. And also, I would like to thank you to both parties for appointing me as a mediator for this session. Feel free to address me by my first name or as mediator. If we could begin with introductions, please starting with the Aurora Beauty. Sedian Berhad.
Good morning everyone, I am TUAN MAISARAH, Counsel for Adr Beauty Sedian Berhad. Sitting beside me is Ms. FADIAH HANIS, the Marketing Director for ABS, and I confirm that Ms. FADIAH is present with full unequivocal authority to negotiate and execute a binding mediation settlement agreement today.
Thank you. And for Pixelras Media Sedian Berhad.
Good morning everyone, I'm RAMESH, Counsel for PRM, and this is Ms. ANEESA FARHANA, our Account Manager and primary representative for Pixel Rise Media, and we also confirm that Ms. ANEESA FARHANA has full and unconditional authority to settle this matter on behalf of Pixel Rise Media.
Okay, excellent. I have reviewed the notice to mediate and the mediation briefs submitted by both firms, and we are here today to address the disputes arising from the Digital Marketing Services Agreement, specifically focusing on the alleged breaches of quality and timelines by PRM, the subsequent withholding of the 120,000 ringgit payment by ABS, and the path forward for the contractual relationship. So, Counsel, is the purpose of today's session to find a mutually acceptable resolution to these issues?
Yes.
Yes.
Okay, the proceeding will proceed as follows. We will start with opening statements from each party, followed by issue identification, where we clarify the core points of dispute. We will then move into joint discussion and, if needed, into caucuses, which is private sessions, to discuss options and interests confidentially. Finally, we move to negotiation and closure. Do both parties understand and accept the ground rules? And are there any questions regarding the process before we commence the opening statements?
No question.
Right.
So far, no questions.
Alright, very well. ABS, as the party that initiated this proceeding, would you like to present your opening statement first?
Thank you, Mr. Hakim. Our Beauty is here today because we seek a resolution to a severely damaged commercial relationship with Pixel Rise Media, one which has cost us a significant time, money, and critically reputational capital. We enter into the Digital Marketing Service Agreement in a good faith, hoping that PRM will be a professional partner. Instead, we receive defective performance. We specifically cite 3 instances of breach. Firstly, the missed content deadlines, which cause us to lose first mover advantage in a competitive market. Secondly, the unauthorized use of unapproved influencers, which introduce the liability risk. And thirdly, the egregious spelling error and content misstatement in the final sunscreen campaign, which directly undermine our product's credibility and our halal certification standards. And the 120,000 ringgit was not withheld lightly. It represents payment for work that was demonstrably defective and in a part never delivered to the agreed standard. ABS is entitled to withhold the payment and until the breach is rectified. Our goal in this mediation is not a retribution but certainty. We need to recover the costs associated with the reputational clean-up and either secure a framework for a reliable professional marketing partnership or agree on a clean mutual termination that safeguards our brand from future harm. We prefer a swift final agreement today over the protracted uncertainty of arbitrations. And we trusted PRM with our core brand message. When errors like that sunscreen mistake occur, it compromises the trust of our loyal customers placed on us. That's all from our side. Thank you, mediator. We look forward to hearing the PRM's response and moving towards the solution.
Thank you. Pixel Rise Media is here because we were the party that delivered the bulk of the contracted services, and we have been wrongfully denied payment for the work that has been carried out. Therefore, we seek immediate release of the sum of 120,000 ringgit, which is overdue payment and vital to our operational cash flow. While we acknowledge some challenges in meeting the original schedule, we strongly contest the allegation of fundamental failure that has been made towards us by ABS. The delays were experienced directly and caused by ABS internal processes. Specifically, the numerous and frequent changes in the marketing direction. And crucially, that has slowed down the multi-layered approval process for creative assets. So the work that was completed substantially complied with the agreement. And to have the full 120,000 withheld is a disproportionate and destructive action that constitute the breach of payment terms by ABS. Our primary interest is a stable commercial environment. We are prepared to address and formalize a clearer, faster approval protocol to mitigate future risk. However, we cannot accept the reputational damage caused by the withholding of funds for work that was already rendered. We put significant resources into meeting the changing demands from ABS, and we need that outstanding payment to cover operational costs and to successfully complete the final elements of the contract. Our objective today is simple: the immediate release of substantial portion of the outstanding funds and a commitment from ABS to a stable and achievable path forward, whether that is a revised contract or an amicable, clean conclusion that respect the value of the services we did deliver.
Thank you both. I've heard ABS clearly state the matter is about reputational damage and quality control, which necessitate the withholding of the 120,000 ringgit. PRM, your concern is the payment withholding and the impact of ABS slow approvals. Instead of focusing on past liability, which often leads to impasse, what are the underlying interests that ABS needs satisfied to move forward? And what does PRM need to maintain its business stability? Can we agree to focus our discussion today on two areas? First, addressing the financial risk caused by the outstanding 120,000 ringgit, and second, establishing a reliable working framework for your future relationships.
Mediator, focusing on a revised framework for future quality is absolutely the most productive path for ABS. And our core interest is mitigating the risk and protecting our brand.
Okay.
We agree. We need clear payment and approval terms. We are open to discussing how to provide the assurance, provided it doesn't leave us financially exposed.
Okay, understood. To explore the possible settlement range and the depth of your flexibility, I will now meet with each party privately. We will start with ABS. Okay, thank you. We are now in a private session. Please be assured that everything discussed here is strictly confidential and will not be shared with PRM unless you grant me specific, explicit permission. Counsel and Ms. Fadiah, let's focus on the commercial viability of your position. You want to retain 120,000 ringgit, but if we fail today, your worst alternative is a lengthy arbitration. Can you outline the cost, time, and most importantly, the risk of litigation where PRM might successfully argue that your late approvals contributed to the delays?
Data, the legal risk is real. Our estimate for defending and prosecuting this case is that around 70,000 ringgit to 80,000 ringgit over the next year. Furthermore, PRM has evidence regarding our internal approval delays, and if an arbitrator finds us partially liable, we could be forced to pay the full 120,000 ringgit plus costs also.
This is substantial exposure, considering that risk and the absolute priority of securing a clean, immediate termination which saves your brand from further harmful exposure. What is the maximum amount ABS is prepared to pay PRM today to buy that certainty?
So we must terminate the contract now. The relationship is unsalvageable, and given the cost and risk of arbitration, we feel securing 40,000 ringgit as a compensation for the restricting cost and reputational impact is fair recovery.
Correct. We have withheld 120,000 ringgit, and if we retain 40,000 ringgit as compensation, that means our maximum payout to PRM is 80,000 ringgit in exchange for a full release of all claims and the non-disbursements clause and the mutual termination also. And this must be the final figure to avoid our worst alternative.
Thank you for clarifying. So your reservation point is a maximum payout of 80,000 ringgit to PRM, which allows ABS to retain 40,000 ringgit and secures mutual termination and a full release. These figures remain strictly confidential. May I share with PRM that ABS is highly motivated to achieve an immediate financial settlement involving mutual termination and a substantial financial concession to PRM?
Yes, please convey that to them.
Okay, now I understood. I will now meet with PRM to explore their needs and find our zone of possible agreement. I will return shortly. Ms. ANEESA, ABS is clearly concerned about the reputational risk. They have 120,000 ringgit as leverage. Considering the public nature of the spelling errors, what are the commercial risks if this matter were to proceed to arbitration?
Mediator, we are advised that there is a significant litigation risk regarding the full amount of 120,000 ringgit. If we could live today with the client secured and reaching the bulk of the payment, that would be a win situation. Our absolute bottom line is we need at least 80,000 ringgit release to cover operational cost and outstanding suppliers payment.
That gives us a clear monetary target. Let's look at the other side of the equation. ABS primary interest is confidence in the quality of future work. So what concrete enforceable steps is PRM willing to offer to ABS to reduce ABS risk and in exchange for ABS releasing the majority of those withheld funds?
To secure the release of 80,000 ringgit, we can implement a quality control checklist that requires a two-stage internal sign-off before submission to ABS. Additionally, we are prepared to waive 40,000 ringgit of the withheld amount, accepting it as final compensation for the past errors, provided that we get written commitment on ABS future approval timelines.
I understand. So the proposal involves waiving 40,000 ringgit in exchange of 80,000 ringgit and a written commitment on future approval times. So are you comfortable with me conveying the concept of the settlement structure back to ABS?
Yes, you may.
Okay, welcome back everyone. Both teams have identified mutual interest in continuing the contract under a new framework. So based on our private discussions, who is prepared to open the negotiation by presenting an integrated offer that addresses both the financial and quality issues?
ABS will present the proposal. To reach a final resolution today, we propose that ABS will immediately release 80,000 ringgit of the withheld funds.
We accept the release of 80,000 ringgit.
Okay.
In return, PRM agrees to waive the remaining 40,000 ringgit in full and final settlement of all claims related to past breaches and services rendered.
Agreed on the financial split. To make this work, the release of the 80,000 is contingent on PRM immediately signing on addendum mandating the two-stage internal quality control process that you have discussed.
We accept the quality control condition. In turn, our commitment to this new framework is contingent on ABS agreeing to a firm 48-hour approval window for all submitted content. We cannot be held liable for delays caused by client inaction.
Okay.
We accept the 48-hour approval window and that constitutes a deal.
Okay, I see the line. The parties have generated a solution. 80,000 ringgit release for ABS agreement to a 48-hour approval window and PRM's waiver of 40,000 ringgit and commitment to a new quality framework. Do both parties agree that this constitutes a full and final settlement of this dispute?
Yes,
Yes. We
Alright.
yeah.
Okay, congrats to both teams on your excellent work. You have reached a full settlement generated by yourself. I will now summarize the core terms that must be captured in final binding document. Okay, term number 1, I will say here, PRM waived the sum of 40,000 ringgit accepted by LBS as full and final compensation for past claims. Term number 2, LBS will release the remaining 80,000 ringgit within 3 business days. Term number 3, a binding addendum will be executed detailing PRM's new quality control process and LBS 48-hour approval window.
Thank you for your skill guidance in helping us navigate these complex issues. We really appreciate your neutrality.
We echo that sentiment. Your facilitation was key to finding this mutual solution today.
Right. You are both most welcome. It was your commitment and strategic decision-making that made this resolution possible. ABS Legal Counsel, as the party's representative, I will look to your firm to prepare the formal, legally binding mediation settlement agreement MSA based on the terms I just summarized.
Understood, Rita. We will prepare the draft MSA immediately and circulate it into the PRM's council for their review and client signature also.
Alright, I think this concludes our mediation. Thank you to all of you.